Hey, let's go ahead and get started. You know that today we're going to be talking about the buyer representation agreement. And I got to tell you something, it's got to be among my favorites, but I got some really cool stuff to tell you about. And you know that it's going to be good, right? Okay. All right. So let's go ahead and launch. We're going to get started off. Here's where we are. I got some new stuff for you today. Here's where we are. My name, my phone number, it's all about me. There's my email address. Thanks for joining us. We're going to talk about the buyer representation agreement exclusive. And when we're done with our conversation, and by the way, it's going to go over the next couple of weeks, but when we're done with this conversation, you won't work with a buyer for nothing, no how, without having one of these signed. I promise you. I mean, it's just, we just have so much fun with this. In our office, we don't work with them without it. In other states where we're brokered, in other states, nobody works with people without it. It's only in the state of Southern California that we seem to have a problem with this. So I'm going to invite you, and I know that people are still coming in. There's quite a few people coming in, but I'm going to invite you to post for me your objection. What is it that, why don't you use it? And secondly, what do you think the client is going to say when you ask them to use it? I've had people say, well, I never ask the client to use it, right, to sign one. And I'm going to counter that with, I would never work with a client without one. And there's a lot of reasons for that. So anyway, let's have some fun today. We're only going to cover paragraph 1 and 2, so I'm going to move it along in a pretty good clip. We got an hour and 15 minutes, not enough time, but I want you to be happy. I want you to get us through this. So once again, we're gonna be talking about stuff that sounds like it's legal. We're gonna be, I'm not a practicing attorney. You all know that. I mean, I say that at the beginning of everything I talk about. And I still have people say, "Oh, he's giving legal advice." I don't think so. My trial work, I do it, expert witness, usually defending brokers. Not intended to be a substitute for the advice of your broker. Please do whatever your broker tells you to do. You hired them, so they're there to help you. So make sure you do that. If you are the broker, well, then you always have me, right? Okay, and not a substitute for the advice of your attorney. So please consult with them as appropriate. So here's something new. So I frequently get asked for the materials from the day. And what I've done is SDAR, and of course, you all know I love SDAR, okay? And so SDAR has said, listen, we'll send them the material because, for me, it's copy, paste, do all that kind of stuff, and it takes me hours, and I love you to death, but I want to get you this stuff fast, and it's taking me a day or two to get to it, and I'm backed up 3 weeks in emails now, and so I just feel like I'm letting you down. So if you want a copy of the material, send an email, education@sdar.com, and they'll send it to you. They're automatically going to do it. So it's just that easy, okay? So send them an email, and of course, you can always say something nice if you like the presentation. If you want to get a hold of me, here it is, okay? Kevin@BurkeRealEstateConsultants.com. I do a weekly email that I messed up big time last week, and I apologize. But literally, I was trying to pretty up the links, the bit links they call them, and I try to pretty it up. And essentially, apparently, I did not know this, but David Martin, God love him, he said, "No, Kevin, they're case sensitive." I did not know that. So anyway, I learned something new, but it caused me to have that one of those rare second emails. And I feel bad about that, and I apologize. And hopefully everybody's able to get in on this. But if you had a problem with it, hey, let me know one-on-one. Let's go. Let's talk, okay? And I'll help you with whatever it is you're having challenges with. That's how we do it around here, okay? So let's go ahead and get started. I want to. Wow, there's a lot of us. I want to get us going here on the subject matter for the day. Where's my dealy bob? There it is. So I need to pull up my, you don't want to see that part. You want to see this part. No, you don't. You don't want to see that part either. You want to see, where's my little window that has the stuff in it? Linda? Okay, all right. Well, we'll do it the old-fashioned way. I'm going to cancel that window, and then I'm going to pull up that window, and there's my buyer representation agreement. Okay, so I know you can't see that, but let's go ahead. I'm going to pull it up for you. Okay, so let's talk about my buyer representation agreement. And as I said earlier, today I want to hear some objections. I want to hear some reasons why people don't use it, because I just don't understand. Like I said, when I'm in Virginia teaching, they're like, yeah, what's the problem? We all do this. It's the law. It's required by law. And you know what? I don't want to say it's required by law. I'm going to tell you that your commissioner requires it, okay? And that's going to be including your DRE commissioner. I was just in Idaho yesterday. They require it. And it's because you need to have an agreement with your client, and that agreement with the client is what separates them from being a customer and them from being a client, okay? And again, you all know I teach this law stuff, so I teach it to attorneys. But at the end of the day, the agreement, you have to have a written agreement with the individual or with the entity. Otherwise, they are just a customer, and you are deceiving them by leading them to believe that you're actually working, that they're your clients. So that's going to be kind of where we're heading on it. But I want to show you how I start off. Hey, Alexander, I want to show you how I start off, and it's I'm going to tell you it's I've taught you all in class before that the very first form that the client ever signs is going to be the agency. Hi, Renee. Is going to be the agency disclosure form, right? Okay, so we're not going to get into agency. That's really a whole nother class. But I'm going to tell you the very first form that's ever signed is going to be my RA form. And so I'm just going to pop it up for you here really quick. I love this form. And again, now that I've messed this all up, I got to try to find things. Here we go. Okay, so here's my RA form. This is my Realtor acknowledgement form. I start every conversation with a client, okay, with the customer becoming a client, whether it's my purchase agreement, whether it's my listing agreement, or whether it is my buyer representation agreement. I started with this form. And the reason why this is so important, listen, you and I do what you do. I'm in your business, okay? And I'm going to tell you that, we're in such a hurry to get out with the contract, such a hurry to get out of there with the agreement, that we forget the little stuff. And as I have said to you before, the more time you spend with the client in the beginning, the better off you are ever going to be. And it will save you countless hours of making excuses, coming up with all kinds of, this and that, but spend time with the client. And so this is a form that I use when I get the conversation started, because part of my intention when I'm starting with the client is that I want them to get used to signing things. I want them to get used to the fact that we're here to do business, and I'm serious about what I do, and I'm professional about what I do, and you need to be as well. So we came up with this form, God, it must be about 15 years ago now. I don't know anybody that uses it. I just think that is a mistake, okay? So let's take a look. What does it say? And this is page 1, all right? And so again, as I said, the very first form the client ever signs is the agency disclosure, but this is the very first form that is ever signed in a transaction. So look what it says. This form is for realtor use only. Use of this form by a non-realtor. Now, a lot of people, even people that are real estate agents, don't understand the difference between a realtor and a licensee. So there are 423,000 licensees in the state of California. 185,000 of them are realtors, which this is what this is going to explain. So if they are not a realtor and they use this form, obviously it's against the law, and it's B&P code 10177H if you're keeping score. Penalties may result in the violator's real estate license being suspended or revoked or denied issuance for new applicants. Folks, remember, you are a salesperson. That is your job description, okay? And your job is to use all of the tools at your disposal in order to accomplish your objective, which is taking care of the client. And sometimes even when they think it's not in their best interest, but in fact that it is, and that's what you have a license for that, okay? So this is really important. If somebody calls themselves a realtor and they are not, the DRE, and I'm going to tell you, this is serious, the DRE will not allow them to take a job as a janitor in a building where there's a real estate office, okay? So this is like, we all minimize all this stuff. Listen, this is your ammo. This is a big deal. So this is page 1. This is the entire page. Let's take a look at page 2. And page 2, and you've heard me talk about these things 1,000 times, folks, and I'm going to tell you, I'm not going to go through it all again because I want to get into this buyer representation agreement, but look at the form. It's the RA. We created it in July of 2006, and we haven't changed it because it says what we needed it to say. Almost 15 years. So I was right when wasn't even think, I didn't even look at the form. I knew it was about 15 years ago. So now here is where I create doubt. I've already created it on page 1. And now the client is thinking, I guess I always thought everybody who had a license was a realtor. when in fact that is not true. Okay. And so I want to differentiate myself from the rest of those people. And I'm going to do that by using this form, and this form is going to help me do that. And I do like going over this with the client. Remember again what I said to you earlier, I am not in a bus trying to get out of this appointment. You know, I am there to do business, and I'm not leaving until I get my listing signed. In this case, I'm not leaving until I get my buyer representation signed, buyer representation agreement signed, okay? So again, I will help you with this. If you need one-on-one, just give me a holler, okay? We'll chat. All right, but I'm going to tell you something. You know, when we're done with all this, you would never go without it. This, and how many times you got to go showing people property, and then have them find the house of their dreams, and they have a sister write it, or an agent of theirs out of San Francisco, or their neighbor has a license or something like that. Listen, I'm going to knock this down. I'm going to nail it down, and I'm going to make this so that we're going to do business together. So here's the explanation. You can go ahead and read it on your own. I'm not going to spend any time reading it here today. I'm going to tell you. You read this and you're going to go, I got it. Now I understand what he's saying. Okay. So I want you to do that. I want you to understand that there is a huge difference between the licensee, and we already know realtors make a third more than licensees make, you know, and we have all that kind of stuff. You need to be proud of it. You need to take advantage of it. You need to express it. Okay. I want it expressed. And look down here. There's a place for you to sign the form. I already have a blank one. I'm ready to go. Every appointment I go on, I got this form. Okay. And so whether I'm going to sign it with them in person, if I send it to the client to sign an offer, for example, this is the first form. When I bounce it from the signature off to the listing agent, this is the first form. Everybody sees this up front. And I can tell you probably 90% of the real estate agents that I work with come back and go, what's that form? Okay, well, because we don't do a good job of telling you about it and tell you how important this form is. So would you all please, I'm going to give you a homework assignment. That's just how I am. A homework assignment. Please spend some time, read this form. Okay, please. And please promise me that you will use it. I think after you've read it, you realize, wow, you know, when I go on the appointment, you know, I sign it in front of the client. I hand it to the client. I go, look, no blood. Yeah, we're here to sign things. That's kind of the general idea. And I kind of break that ice and move myself into what we're going to do next, which is we're writing an offer on a property. We're taking a listing on a property, or we're going to do a buyer representation agreement. We're going to work together with each other. Ken Kaplan, he's an awesome guy, and he calls it the buyer loyalty agreement. So everybody good? Anybody have any questions about that? I think it's a really important form, and I want to make sure you're comfortable with it. Okay. All right, let's go ahead and launch into our buyer representation agreement. So again, the reason I brought that up was because that is the first thing I get going with my client, because that's going to be my close. Listen, I'm in real estate. I need closing techniques. And so when people call me up and they say, well, I can't close a door, and I'm saying, well, let's talk about your style. What do you do? And I want you to make that yours. Okay. All right. So let's talk about my buyer representation agreement exclusive. So now and again, remember that, you know, after you did the RA form, remember that you got your agency disclosure. You got to have that in there. So you got your agency disclosure. We've, you know, thank you to Chris Anderson, who made a great comment one day. She said, we ought to have that agency form in front of all of our offers, all of our listings. And we did. We just went universally we changed legislation. We made it, you know, used to be commercial, didn't provide an agency disclosure, and they all do now. A lot of people don't even know that they weren't required to do it. Now they're required to do it. Now agency disclosure is required in all of your real estate transactions where a real estate company is involved. Okay. All right. So let's talk about this. This is big stuff. Now, this is fun stuff. And again, I want to hear your objections. If you got a problem with it, I want you to let me know. This is the form I'm going to use. We have 3 forms, much like we have 3 listing agreements, right? So remember that you have to have a listing agreement with the client before you can market the property for sale. Otherwise, it's what? False advertising, intentional misrepresentation. Okay, so you got a couple of torts you're going to have to deal with. You must have a contract with the seller. DRE says you must have an employment agreement, and the listing agreement is the employment agreement when you're working with a seller. The buyer representation agreement is the employment agreement when you're working with the buyer. And I'm going to tell you, as much as you might think, oh, I'll never do that, or stop listening to people that have been in the business for a long time that are telling you, oh, I'll never do that. Oh, what is he, nuts? He's telling you to use that form? Listen, get away from these people, okay? They're obviously not producing. So, the bottom line is I want you to be very comfortable with this form. When you realize that this form is part of your tool and that you're going to use this, listen, I look forward to the opportunity of sitting down with a client. I went out with one of my agents on Friday to a seller. Seller says, I'm not listing the house unless I talk to Kevin first in person. I literally flew in to meet with a client. Okay. And what a great meeting. I love the guy. Okay. But you know what? He's ready to, it's showtime. He's ready to go. And that's what we're going to do. Okay. All right. So bottom line, buyer representation agreement. The one we're going to talk about today is the most robust. So it's the equivalent of the RLA. All right. This is the BRE. So that's buyer representation agreement exclusive. Now I like CAR and I like what they do here because, as you've heard me say before, I never use the word contract. I never, because that's contracts are what people are trying to get out of. I always use the word offer or agreement, and in this case, CAR says this is the agreement. And so, it's not as onerous as contract, but contract is what we're going to call it when somebody tries to get out of it. And I had this happen. I was management at a very large brokerage that I was doing San Diego County and San Clemente County, and San Clemente and Orange County, and had somebody, a buyer, go off and buy a property from from another agent. They had an open house, right? Buy it from the open house agent, and they had a buyer representation agreement. Needless to say, our agent got paid, and so they bought it during the time period. You always know when your client has moved on and bought with somebody else when they stop returning your calls. Everybody got me? That's when you know, and you don't want to wait for that. You want to have a relationship with them. So let's take a look. So I'm going to have a couple of key elements in here. I'm going to have my exclusive right to represent. So you remember the exclusive authorization and right to sell. This is the exclusive right to represent. Okay, so now I'm going to have my buyer's name in here, and your buyer can be a natural person, your buyer can be a non-natural person, one or the other. They either bleed or they're an entity of some kind, and that's the name that's going to go in here. And if they're going to be a non-natural person, someone other than a natural person, then you're going to use your RCSB, RCSD-B. And by the way, we just updated that form that went into your library as of last week. Okay, so that it was the only RCSD form that we updated, and that is the RCSD-B, which would be the form that is associated with this document. Okay, everybody good with that? All right, so grants. So remember that your RLA says employs and grants, right? That's the linking language, and here we have it again. Grants, okay, and then the broker's name. So in here, you would have the broker's name. If you are the broker and your company name is named after you, then your name would go in there. But this is the broker. This is not you individually, okay? Everybody good? All right, okay, beginning on. So remember, DRE requires, the law requires that your contract, your agreement must have a beginning and an ending date. And again, state exam question, I teach the state exam, so I'm going to tell you it's on the state exam. You must have a finite period, otherwise it becomes kind of like an option, okay? So we don't want to do that. We want to have a beginning date and we want to have an ending date, and you can have that beginning date be whenever you want it to be. If you don't want to start representing them until Friday, then put it in Friday, okay? And then whatever day you want it to end. And how long does it have to be? Well, there is no rule. You can have it as long or as short as you want to have it. Maybe you have a client coming in, maybe you're new and you're a little timid, and you have a client who wants to go look at property on Saturday and Sunday. Make it for Saturday and Sunday. You can always extend it, okay? Everybody good? You can always extend it. But you got to have a beginning and an ending date. So I've had people do them at open houses. We're going to go look at property. They come into the open house. We're going to go look at property tomorrow. Okay, here, we're going to have you sign one of these. It'll be for tomorrow only. Maybe that's how you do it, but it has to have a beginning and an ending date. So in our office, we do them for 3 months. I'm concerned about someone that does them for 6 months or a year. I've seen people do it, but I think you might get into that area where it may not be enforceable. The listing agreement, what, 6 months, a year, buyer representation agreement, 3 months, 6 months. I think if you go too long, but remember, it is an employment agreement, which means that they agree to work with you, but you also have to work for them. And so you might not want a really long agreement with someone. If you sign a 1-year agreement with someone and it doesn't work out and they're not going to let you out of it, you're going to have to be doing some stuff to try to exit that agreement. And so you might want to take that into account when you decide how long you want it to be. And again, your decision, short, long, whatever you want. Okay. All right. And note that it ends at midnight, 11:59 p.m. on whatever day, or completion of a resulting transaction. Why? Because if you complete a transaction, then you're done with the agency relationship with the client. You don't want this to continue. Hypothetically, they're not going to buy another property right away, but again, we're going to talk about the terms of this agreement to decide whether or not we want it to continue after that. So note that in your form it says whichever occurs first. I don't know where my I don't know where my pointer is. I hate it when I do that. I do know where my pointer is. This is called being prepared for the presentation. I forgot about my pointer. Okay, because you all know that I love to do annotations. So let's take a look at my annotator here, and you're going to see why it's important here in just a second. Okay, so look at my annotation. Whichever occurs first. Okay, so either it's going to be my, termination date will be a date certain. Remember, the law likes a date certain, or it's going to be the completion of a contract. Okay, the exclusive and irrevocable right. If you ever wondered how that was pronounced, it's exclusive and irrevocable, which means you and me together, we're it. Okay, on the terms specified in this agreement, we have to have terms, and we're going to see those here in a second. To represent the buyer in acquiring real property, folks, please, real property. Okay, I see people doing like washers and dryers and refrigerators. Personal property, I don't have a license for that, and clearly I don't have a license for jewelry. Okay, all right, so, or a manufactured home. Again, it has to be a manufactured home, can't be a mobile home. A mobile home is one that is mobile, it's on wheels, it's not affixed to the foundation, can be easily moved. Okay, all right, so as follows. So let's take a look at our as follows. So what kind of property are we talking about? The property to be acquired: any purchase, lease, or other acquisition of any real property. And mind you, remember your lease, there's going to be some conditions for that. Maybe a 99-year lease, that becomes real, right, versus personal, or manufactured home described as. Okay, now you have to put something in here. You can't leave it open. Okay, and the reason is because your contract will fail for vagueness of purpose. All right, you don't excuse me, you don't have a definiteness of purpose on that, and so they're going to want to have something so what are my criteria? Location. Now let me help you with that a little bit. So location. So you could put a street address, right? I mean, that's pretty, 1234 Camino del Mar, my old office, right? Camino del Mar, I can put a street address, which means that if the buyer buys that property during the period of time of this agreement, then the buyer agrees, A, to work with you, and B, make sure that you are compensated. And again, compensation is going to come next week. I'm sorry, but compensation is a whole day. So it is really fun. When I get into that, you're going to see, well, now I get it. What's the problem? I've been avoiding this form all this time, and it was all because I thought it was all about compensation, but I'm going to talk to you about how it isn't, okay? All right, so I know Linda Hernandez is on here, and I usually don't mention last names, but I love Linda, and I know you're laughing because you've heard me say this before, okay? So I'm going to have a location. So, and again, if you're not going to pick a specific address, I'm going to tell you, don't be overreaching. So if you put in San Diego County, it's probably not going to be enforceable. Okay, but if you put in, we recommend 5 zip codes. Put in 5 contiguous zip codes, or 5, zip codes. You can always modify it. You can always amend it. If the party comes back and he says, well, originally I was only looking at 92014, 92075, 92130. But now I'm willing to go to, 92067, 92129. You can always amend it, okay? And amendments are good because in this scenario, amendments show that the client believes in the authenticity of the agreement at the same time that they're willing to move forward with it in other respects, okay? And then what about other? I can put other things in there. I can put in, a house that faces due west, whatever. You can put those kinds of criteria in there. But the most important thing in this for this part is going to be the location. Okay, you can have a specific address. You can also give them a list. Now, I know some of us are tempted. Well, I sent them this email that had all the listings. That is not going to protect you because we're going to find out in a little bit that you must physically introduce them to the property because, used to be that, oh, I sent them the list. They've got to buy from me, that kind of thing. Yeah, that's not how it works. I'm sorry. Just way too easy. And you know what? Frankly, courts just aren't going to enforce it. Okay. So we want an agreement that actually has some teeth in it, and it'll be up to you. We tell the agents in our office, it's going to be up to you whether or not you want us to enforce it. But you know what? At the end of the day, you got to at least do it. And so, I'm finding, and I'm not getting anybody telling me, a challenge that they're getting, but I'm going to tell you, the majority of people that don't use these agreements are people that never have. The people that just resist it until the day, if we didn't require you to have a listing agreement, you'd never do that either, right? So, there are certain leaps of faith we're going to have to do in our business. We're going to have to get past certain things where I just never have done it. Well, how about let's try it, okay? You'd be surprised. I've never had anybody turn me down. I don't know, am I that convincing, Alexander? All right, maybe I am. Okay, so, but the thing is, I've just never had anybody turn me down. I've got that presumptive close about me, right? I'm sit down and explain it to them. Now, I don't spend nearly the amount of time explaining them to the client, as I am with you. But I don't just go initial here, sign here, bottom copy's yours. I don't do that, but I am going to spend time with them on it because remember, I want them to appreciate, what's going on, and I want to avoid the parking lot kiss off. I want to avoid them getting in the car and I never see them again. I'm going to have this agreement with them. Okay. All right. Okay, good. So then I have to also, I'm sorry, I missed it. Price range. You got to put in a price range. So it's kind of like a value range, right? But you can't put a listing in the MLS that goes from $1 to $2 million. Okay. MLS is going to say, you're violating the 10% rule. We're not going to allow that. All right. But as far as price range for my client is concerned, I'm going to probably pick a hot number. So presumptive close. You know what, Alexander, I'm a pro with this. Okay. When it comes to closing people, listen, I think I'm a fairly decent instructor, but when I'm on an appointment, I know when to stop talking, and that is key. And I keep saying I want to have a negotiation class with all of you because you know what? That negotiation is what we don't teach you anymore. And it is take the Xerox sales course, one of the best courses on negotiation. It's been completely muddled with all the internet stuff now, but I'm going to tell you, it's a great course. I took it 30 years ago, and I still believe in it. So, I'll get people going, I'll get them all excited. And once they start getting excited with me, I just back up and shut up. Linda says, you're amazing on an appointment. You are not the guy I know, right? And so she says, you know what, you're actually pretty good. But I just do. I just have fun with them. We're having a good old time. But at the end of the day, I'm making the decision whether or not I want this listing, okay? And this buyer, I might decide I don't like this buyer. I might decide, maybe I'll work with you on Sunday, but I may not want you after Sunday. So I'm going to just have a Sunday agreement, right? We're going to go Sunday, go on a meeting or whatever, and I may, and then we can extend it later, okay? So price range. How do I determine my price range, Alexander? So here's how I determine it. First of all, I'm not taking you in the car unless you've been approved for a loan, right? If you're cash, I've seen proof, okay? But if you are going to get a loan, now these are things I'm going to have to give the listing agent, to give to the seller at the time of an offer anyway. So let's go, showtime. I want to see. So have them pre-approved by a lender, have them pre-approved by a good lender. Okay, you want a lender that closes deals. You want, anybody can do loans, right? NMLS or whatever. But you know what? I want to work with a good lender. And I got a couple of good ones I really like. And that lender is going to make the difference between whether you're going to do a deal or not. So that lender to be a better closer than you are even. And anybody I send to one of our lenders, our list of lenders, are all going to close the client for me. That's why, I don't take them out in the car without having been pre-approved for a loan. They don't want to do it at the time. Oh, don't worry about it, I'm okay, or that's all right, I got plenty of money, or what are you doing asking me if I can afford to buy the place? Well, I didn't ask it that way. I didn't say, can you really afford this $1 million property? I know I can, but I don't know if you can. So I don't ask the question that way, right? I said, let's get pre-approved for the loan. The reason being that when we present our offer, we need to have that pre-approval letter go along with it. And so that pre-approval letter is going to make or break this deal. You've got 10 offers you're competing against. Listing agents looking at your offer with no pre-approval. I've got a couple of these right now. They just refuse to do it. And it's like, I'm not working with you. Okay, I got other things to do. I might be writing an offer on that same property for another client, and that one's going to get the deal before you are, because you got to be able to prove that you can afford to get the property. Okay, so that's why. So my pre-approval letter, so whatever I'm going to be, so the bank says to me, okay, the client can qualify up to $1 million. So I ask the buyer, I say, whoa, what price range you want to look in? We know you can go to $1 million, right? So what price range? And they always tell you, well, I want to go to $2 million. And you're sitting there going, you know what? You can't, your lender told us you can't do $2 million unless you're going to win the money in Vegas this weekend or something. But I think you're $1 million, right? So my numbers in here on $1 million, I'm going to probably be doing 800, because people looking at $1 million are rarely going to go below that. And I'm probably going to go as high as maybe what? In this economy, maybe 1,000,001, right? Because why would I go higher than that? I mean, if you can only afford $1 million, and of course your buyer's thinking, well, I can always negotiate. And it's like, yeah, I know, but you can only negotiate to $1 million. And so, all right, fine. But, invariably, and the experienced ones among you who are out there know what I'm talking about when you say somehow they find the money. It's just like in a shoebox in their closet or something. I don't know where they got it, but I'm going to leave myself open, because remember, if I put in 800 to 1,000,001 and they write an offer for something for 1,000,002, they don't have to use me. Okay. But again, I can't do 1 to 2 million. That's a no-no. It's just not going to be enforceable. It's like saying San Diego County. So I have to put in a number that is realistic, and I'm going to start off with my pre-approval. What does that number look like? And then I'm going to work my way around that to cover all the possibilities. Over here, they end up doing it $1,000,001 because mom and dad, give them $100,000, money to their dowry or their curtsy or whatever. Okay. I like using those words. Nobody uses them anymore. Okay. Is everybody good with that? So I got to have a price range in there. I'm going to look at that pre-approval letter, but if your client says I'm not going over 800,000, then you need to adjust your numbers. Okay. But keep that range. You don't have to keep it incredibly tight, but you got to keep it tight enough that it'll pass muster. Okay. Everybody good? I think I have a second question. I'd list with you. Thank you. I appreciate that. It's funny you say that, because when I do how to do the winning listing presentation, I talk about, that sometimes my close is like subtle as a freight wreck. No, I don't want your listing. And then they won't let me leave. Right. So, I'll show you how to do that. It's okay. So, all right. So let's go back. Again, I already covered 2, I covered 3. Let's take a look at B, okay? Broker, so remember, this is an agreement with your broker. Much like with the listing agreement, you are signing on behalf of the broker, okay? So the broker is by law the agent. We often think we're the agent. We're not the agent. We are an agent working on behalf of the broker. So when we do the class on agency law, we can get into it really deep there. Hi, Don. Don, looks like you started a type of question. Okay, broker agrees to exercise due diligence. Remember, we've got to have the quid pro quo and reasonable efforts to fulfill the following authorizations and obligations. All right, so let's take a look at this, and I'm going to show you a really powerful close I have for this, okay? Number C, broker will perform its obligations under this agreement through the individual signing for the broker below or another real estate licensee assigned by the broker. Okay, so sometimes we have dual agency, and the client says, "I don't know, you're my agent by contract, but now your company represents the seller, and so maybe, or you have the listing. I'm buying your personal listing. Okay, maybe I want another agent to represent me, and that's when this happens." And we have this. So, for example, in some states where I teach, they don't allow dual agency. What they do is they spin on it a little bit, and they have what they call designated agency, which means that the broker can assign another agent to represent the buyer when the buyer's agent happens to have the listing that the buyer wants to buy. Okay, and that way they have designate. So it's kind of a legal fiction. I'm sorry, it's still dual agency in my law, in my book, right? But that's what designated agency is. Okay, so who is either a broker individually or an associate licensee, and then explains what those are, who works under the broker's real estate license. Buyer agrees. Buyer agrees that broker's duties are limited. We're going to that's powerful. Are limited by the terms of this agreement. So how many times we got to say this? So I want to, if I define my duty, define my duty, I limit my liability. So this is the answer to the question where the buyers just sue us for all kinds of stuff. Well, they do that because we never told them in writing what we're here to do. So the buyer just, I had a buyer bought a property from me. It was my listing. It was right across the street from my house, and I sold the house across the street. Buyer comes in from New York and buys the house. A week later, they're calling me on the phone. You're a lousy realtor. I've never had anybody say that. It just doesn't work. And so what's the problem? They said, well, you forgot to call the utility companies and tell them to turn the sewer on in my name, and now my toilets are backing up. The utility company, this was 1983, by the way, utility companies weren't talking to me then, right? I mean, the rule was you had to set up your own utilities. And so this person didn't understand California, in fact, that was in Tucson, Arizona at the time. Here they were coming from New York. I guess that's what the agents did in New York, but that's not what we do here. And so here they were unhappy. I want to limit my liability. And the way I do that is I tell them, this is what I'm going to do for you. So here's my quid pro quo in my contract. You agree to work with me. I agree to work with you. That's my quid pro quo. Okay. But I'm going to tell you what I'm going to do, and I'm going to do it in writing. Does everybody understand? This is one of the most powerful parts of this conversation is I want to define for them what I'm going to do. All right. And I'm going to show you when we get to paragraph 5 and 6, and that's not going to be for a couple of weeks, but 5 and 6, and I do this in my law class, I make the attorneys write 5 and 6, type it out. I make them type it out. You know how like right now everything's in word wrap? They got to type it out in order, in chronological order according to the document. By the time they're done with that, they go, wow, I get it. Now I know what you do. Whoa, big. Okay, but we're going to get to that. That's going to be a homework assignment for later. Okay, the homework assignment for today is going to be really simple. Just do the RA. I want you to read the Realtor Acknowledgement form and go through it. Okay, if it's in zip forms, just type in RA or send me an email. I'll send you the item. Okay, so buyer agrees that broker's duties are limited. I need to limit my duty. Right? Because if I limit my duty, then you're not suing me for all kinds of crazy stuff, like you didn't turn the sewer on in my name. What is that? And by the way, there was no lawsuit. You're just angry, but probably one of the few angry people I've ever had in 41 years of doing real estate. I'm getting to a point where people are fairly happy with what I do. I don't know, but anyway, but I am still going to limit it. I'll help you to the end of days, but I'm not going to give you legal advice. I'm not going to give you tax advice. I'm not going to be your CPA. I'm not going to give you medical advice, right? I stopped telling people taking aspirin at night, because, that's like, okay, some people are allergic to aspirin. It's like, I guess I'm going to offend somebody. So I just don't give that kind of advice. Okay. By the terms of this agreement, including those limitations, what did I say? Paragraph 5 and 6. See this? That you're going to love 5 and 6. We get to 5 and 6. Okay. Everybody good? Because I'm going to go to another page. Let's see. Questions. What is the difference between 1A location and 2D specific properties only? Okay, so Don, you might have got here a little bit late, but that's okay. Don't worry about it. So location for us was going to be zip codes. I like zip codes, but I do not want to say San Diego County. Don't do that. It won't be enforceable. Okay, so I usually teach people to do 5 zip codes. Anything more than that is just starting to look like, you're just trying to load the pot, right? Okay, so I'm going to say on location, I might say 92014, 92075, 92130, something like that, okay? But when I talk about specific properties, maybe I've created a list, maybe, it's going to be this address right here, 1234 Camino del Mar, okay? But I have to be specific in my contract. I can't leave it open-ended, okay? All right. And so and by the way, your client's going to appreciate that. And your client's going to say, what's the difference? Why don't you just make it all San Diego County? And you're going to say, because you know what, I'm here to help you. And I want to make sure I'm only covering those zip codes that are important to you. And zip codes are good. You could also put in there, west of I-5, south of Oceanside Boulevard, north of Encinitas Boulevard. You could do things like that. That's okay. But that would be more appropriately under location than anything else. Okay. All right. Great question. Thank you so much, Don. I appreciate your question. Looks like I got another one in here. I'm sorry. Okay. Yeah. But it's actually a really good question, because for me, it's got to be an either or. So you're either going to do 1A1 or, sorry, there it is, or, you see what I'm saying? So I like that or statement, okay? Because I want to be careful about making it look like too big an area, and so, and again, as we've said, people can modify it. They say, oh, we've decided we don't want to do Oceanside. So we'll go right here. We're going to cross off Oceanside, okay? Have everybody initial it. Good. Okay, good. All right, good. Okay, let me clean that up. So we go to the next page, go to that. Okay, any other questions on this page so far? I do want to help you. But if you have questions, let me know, okay? And you all know you can get a hold of me later too. Okay, so it doesn't end at, whatever time. Uh-oh, don't do that. Okay, so let's go to the next page. Let's take a look at, agency. There's that conversation regarding agency again. Let me tell you, the DRE loves conversations about agency. I tell you, and y'all know I love Veronica Kilpatrick, right? But she is good on agency. She knows what she's talking about. I just found notes when I was on at New Laws in February, my panel discussion when I got to sit next to Veronica, and it's always a high point in my life, right? Because she's just got stuff comes out of her mouth, and I wrote everything down. I write, listen, when the DRE is talking, I write it down. Okay, so it's important. So let's talk about agency. I want to talk about, the things that we all know and love. Okay, so agency relationships, agency disclosure. When I'm done with this, you're going to realize how easy this is. Okay, so agency relationships. So starting off here, number 1 is going to be disclosure. Okay, unless the property is 5 or more residential dwelling units. So remember, Civil Code 1102 is the civil code for residential 1 to 4. Okay, anything 5 or greater becomes UCC. Okay, and UCC is going to be what? Uniform Commercial Code. So 1 to 4 is covered by Civil Code. 5 and greater is covered by Uniform Commercial Code. Okay, and someday I'll show you the book. It's like this big deal, right? I mean, you look at this book. It's like a little Merck manual, a tiny little thing, and you're looking at it and go, oh, really? All the laws are in there? Because here's how commercial works. Y'all be careful out there. That's how commercial works. Okay, all right. So unless the property is 5 or more, again, residential dwelling units, the buyer acknowledges receipt of the CAR form AD prior to entering into this agreement. And I had a really good conversation with Neil Kalin, one of the staff attorneys at CAR, and I said, did you intend to have that box checked, and that we can't uncheck it? And Neil made a great comment. He said, Kevin, he says, we're molding behavior. Now he may not even remember saying that, but I just thought, that's good. We're molding behavior. We want you to know you must disclose agency prior to committing conduct that constitutes agency. And the law says before you write an offer, before you take a listing, before you do a buyer representation agreement. Got it? So we're just going to assume that you have disclosed agency, and by the way, in writing, okay? So we've attached it to this form. So you can't go in, pull up the buyer representation agreement and not see the agency disclosure. It's right the first page, okay? Because it has to be the first page. Remember what I said? The very first thing we ever have a client sign. Okay, so everybody's good. You all understand prior to entering into the agreement. Number 2, B, buyer representation. Broker will represent, as described in this agreement, buyer in any resulting transactions. Why I like this form, because this is the more powerful form. Okay, let's take a look at number C really quick here. Okay, so C, possible dual agency with the seller. Now we've already talked a little bit about this. Okay, so C1 applies unless 2, 1, or 2 is checked below. So if this is going to apply, so this is the default unless we check one of the other boxes, and I'm going to tell you not to, but that's up to you. Do whatever your brokerage business model says to do. Depending on the circumstances, okay, it may be necessary appropriate for the broker to act as an agent for both the buyer and the seller. Now we call that the law calls it dual agency at the same time that you and I call it getting paid double. Okay, so we think of it in terms of I get both sides of the deal. Okay, so it's not against the law in California to do that, but we have to make certain disclosures. And so, and you know what, as excited as you get, you can't forget this part. So that AD form, the page 1 of the AD form, you know, first it talks about the agent representing the seller. Second, remember the agent's the broker. Second part, the agent representing the buyer. And the third part, what happens when the agent represents both the buyer and the seller. Okay, and in some scenarios, you know, there are brokerages that will not allow it. Okay, I know that in our office, we have attorneys in our office that are acting as salespersons and brokers, and they won't do dual agency. They're just like, I just can't do it, because in the legal field, that's what we teach them, that you can't be fair and impartial to both clients on opposing sides of a transaction. If you think of real estate as an opposing transaction, okay, so that's important. So literally we substitute, and we do like the designated agent thing when we have that happen. You know, one of our brokers is a bankruptcy attorney, and he does a lot of short sales. We get a lot of transactions that are short, and he represents the seller, but then along comes the buyer that wants to buy the property from him, and he just can't do it. His brain just says, I can't do it. No. And so then we just assign somebody else. So there is that possibility that we're going to represent both the buyer and the seller, exchange party, or one or more additional parties, okay, for the seller. Okay, so let me, now that I've made that clear as mud. Broker shall, as soon as practicable, I love that word. And how many of you use that word in a sentence? You know what? They made it a word. I mean, it's kind of like Google wasn't a word before, right? So now if you go to page 2 of that AD form, you'll see that that word is on the form, and this language is also on that form. So disclose to the buyer any election to act as a dual agent representing both buyer and seller by definition, right? If the buyer is shown property listed with the broker, the buyer consents to the broker, here I am, way writing too much stuff in here. Buyer consents to the broker becoming a dual agent representing both buyer and seller respect to those properties. Okay, simple, okay? In the event of dual agency, buyer agrees. What? Dual agent may not, without express permission, express means in writing, permission signed by the party of the respective party, disclose to the other confidential information. And then here's the lawyer stuff, including but not limited to facts relating to either the buyer or seller's financial position. So you can't tell and this is so commonly violated, where the listing agent tells the buyer's agent, oh yeah, the seller has to sell, they're going through a divorce. You know what? That is so against the law. You may not do that, right? You're disclosing they're getting a divorce. They're filing for bankruptcy. Listen, we got to be really careful what we tell people. You can't have that conversation. So buyer or seller's financial position, motivations, bargaining position. I did a class this morning on God, what did I do it on? Oh, Lord help us. New forms, and we talked about the new PVOH form, which has right in there, paragraph 1, there are recording devices out there, folks. And so we've got some really good lawsuits, if you consider lawsuits good, where the buyer is suing everybody because the seller was recording the conversation of, that the buyer was having with their agent in the house. They thought they were having a private conversation when in fact it's being recorded, and the seller uses that in the negotiation, okay? So, or other personal information that may impact price, including the seller's willingness to accept a price less than the listing price or buyer's willingness to pay a price greater than the price offered. This is in the agency disclosure. So you need to be reading that form. That is one of the most important forms you need to be reading in real estate. And as some of us, you've been in this business for 5 years and you haven't read the form, I'm going to tell you, something, I expect that you haven't. Okay, most people haven't read the form. you need to read the form. Okay, so it is probably, along with disclosure, obligation to disclose, TDSs, things like that, the #1 reason I get hauled into court. Okay, and again, you all know I love to go there, but listen, if you don't need me, read it. Okay, all right, I'm not going to give it to you as a homework assignment. Okay. So it says right in there that we can't tell the seller what the buyer is willing to pay. We can't tell the buyer what the seller is willing to take, right? All right. And except as set forth above, dual agent is obligated to disclose known facts materially affecting the value or desirability of the property to both parties. The Strasburger case. Okay. All right. So yeah, got an obligation to disclose no material facts. Like for example, the buyer says to you, I want to buy the house, but I don't really have the money. Well, that's material. Okay, so you might want to tell everybody that the buyer can't buy the house. Okay, everybody good so far? All right. Or, and here's my or statement: single agency only applies only if one or two is checked below. Okay, so I'm either going to have possible dual agency or I'm going to have single agency. And so #1 is if broker firm lists properties for sale, buyer understands election will prevent the broker from showing their property. Okay, I don't know why you would do that. Or 2, broker's firm just plain doesn't list property. Okay, so no harm, no foul. All right, so those are your 2 possibilities. Okay, so I flew through that, but I think I saw some questions coming up. So let's take a look at our questions. Okay, what is the difference? I got it. Thanks. Thank you, Don. Renee, can't disclose details like divorce, etc., only as dual agent. No, you can't under any conditions. Renee, it's a good question, okay? And I see it violated all the time. It used to be, and then we finally had enough lawsuits that put it away. Agents would put on the flyer, divorce forces sale. You're trying to talk about, why the seller is trying to sell the house, and then you're overdoing it, all right? So we don't want to put divorce forces sale. It's a violation of Privacy Act. It's against the law, okay? But people were doing it. We did it. We did it up until about 25 years ago, and then we stopped doing it. And hopefully you don't have that memory of that. But it was like people putting on, divorce forces sale, or everybody's in trouble, or all that kind of stuff. Listen, I handle a lot of divorces, none of which I'm responsible for. And I got to tell you something, unless I've got something in writing from both parties that, it's a divorce, then it's not going to go anywhere. I'm not going to tell anybody. And I've had some cases where the agent has gone out, listed the property set for sale by one, got a listing only by one of the parties, and then the other party, when it came time for the offer to come in, the other party says, no, I'm not signing it. I didn't sign the listing, I'm not signing the offer, and you can't make me do it. And oh my gosh, if I tell you how much fun the lawyers have with that. Okay, so yeah, so the answer, Renee, is yeah, you can't disclose personal things, and divorce is personal unless you get something from everybody that says that they've authorized you to disclose the fact that they're going through a divorce. I had one of my agents ask me once, and I just loved her to death, and she didn't, unfortunately didn't stay around very long, but she said, she was getting ready to go through a divorce. I didn't know it. And she says, is there any such thing as an amicable divorce? And my immediate answer was, I don't think so, no. And you know what? She proved it. It was not amicable for her, and it was her deal. But at the end of the day, somebody's going to be angry. So let's try to keep everybody happy. Okay. So thank you, Renee. Good question. All right. Let's take a look at the any questions on this page, and then I'm going to move us on to the next page here. And we're almost doing really good. We're almost done. In fact, this is the last page. But I do want to show you one other. I'm going to show you. I want to finish this, and then I want to show you one other form. Let me see. New shares is still up there. Yes, it is. Okay. All right. So I want to show you this other form. And it is the confirmation of real estate agency relationships form. So we have the obligation, and again, straight from the DRE, we have the obligation to disclose the concept of agency, but then we must also confirm agency. So you all know, when I'm taking the buyer's listing, when I'm listing the buyer, I must disclose the concept of agency, because I don't know who the agent for the seller is going to be. So I don't know if I'm going to be single agency or dual agency. And I'm going to tell you how important this is. You lose your license if you don't do this. Okay, you work too hard to get it. I don't want you to lose it. Let's keep the license. In every state that I go, you don't disclose agency, you're out. Okay, a very large brokerage, had $66,000 commission taken away from them because the transaction coordinator discovered the day before it closed that that no one had disclosed agency to the client. And you know what? DRE stepped in and said, too late. This has to happen before you write your offer, before you take your listing, before you do your buyer representation agreement. So that agency thing, I'm telling you, and again, I do trial work on it, so I can make that last for 2 hours. I've had it last for 2 hours in trial, and I've had attorneys walk out with me and say, I didn't know that. Okay, so agency is incredibly important. We have to disclose the concept, but then we must also confirm. So when I'm writing the buyer representation agreement, I only know who my buyer is. I know that at this point, I only know that I'm single agency, but I could later on become dual. Same thing occurs when I take a listing of a home for sale. At the time of the listing, I know that I'm the agent, so I know that I have single agency at that point. I don't know if I'm still going to be single agency when the buyer's offer comes in, or whether I'm going to become a dual agent because it's from the same company, okay? So then I have to confirm. And you all know the RPA, paragraph number 2, the residential purchase agreement, paragraph number 2, confirmation of agency relationships. That's where we have to confirm it. The funny part about it is that paragraph used to be back paragraph number 16 or 23 of the contract. And it was amazing to me that Veronica even made the comment once. She said, yeah, you all moved it up to the front. We had to, because nobody was filling it out. So nobody was confirming agency. So therefore, we never finished the job. We had disclosed the concept, but we had never confirmed it. And then everybody's losing a license. And the DRE, sometimes they just sit back and they just go, they don't say anything. I mean, I've had this conversation with them about the buyer representation agreement. They go, listen, I don't need a bigger hit than that. Okay, so I want y'all to be good, and so I want this to work for you. So let's take a look at my other potential buyers. And I'm going to get this going here. So other potential buyers, number D. So buyer understands that other potential buyers may, through the broker, consider, make offers on, this is that other disclosure and consent for representation of more than one buyer or seller, right? Remember that? Okay, make offers on or acquire the same or similar properties as those that this buyer is seeking to acquire. Buyer consents to the broker's representation of such other potential buyers. Okay, so again, do I need my my PRVS form when I'm representing in this situation? And the answer is, I've already got the language right inside of here. I'd probably do it anyway, but this is that same language. Okay, so buyer consents to the broker representing other buyers that are going to be possibly competing with this buyer. We put it right in the agreement. Okay, so during or after the representation period or any extension thereof. All right, remember your buyer representation agreement, if you're doing it for 3 months, you can always extend it. Okay, there are situations like even in this economy right now where the buyer has the buyer may not be able to find a property within 3 months. I mean, it's going nuts, right? I mean, multiple offers and everything. We've got multiple offers and everything we have. I need to go out and you need to help me out. I need you to get more listings. Okay. All right. Let's talk about non-confidentiality of offers. So, I informed an attorney client of mine that back in January of 2008, the National Association of Realtors amended the Code of Ethics to say that the listing agent, with permission of the seller, may disclose the content and terms of competing offers to competing buyers. Oh God, it set the whole industry upside down. Everybody was going, well, wait a minute. No, you got to keep those offers confidential. Well, NAR was able to convince DRE, among others, that, it might be in the seller's best interest to let the listing agent tell buyers about content and terms. It doesn't say they have to, it just says they may, and they may, obviously, if it advantages the seller. Okay, so that's really cool stuff. I mean, I sat there and I went, oh, I get it. Okay, what a great idea. Okay, so now you bring me an offer. You're still going to run into people who are going to say, I can't tell you. I'm sorry, you can. January 2008. Here, go look it up. Here's the memo. This is what happened. Yeah, you can tell me. And frankly, I will. I'll make the decision if I get an offer on one of my listings on how much I'm going to tell people. Okay, in the old days, we would play games with it. We would say, well, you're getting warmer. Listen, let's be adults about this, okay? All right, so non-confidentiality of offers, all right? Whoops, my screen moved. I hope I didn't do something bad there. Buyers advise that seller or the listing agent may disclose. Here you go. Just the existence, terms, or conditions of buyer's offer, unless all parties and their agents have signed a written confidentiality agreement. So that's my, my NDA. I've never seen anybody do it. Okay. All right. Now what did I do here? Now I changed something. Gosh darn it. Okay. So I've never seen anybody do it. Fine. All right. But just understand it was what I just told you a second ago. Okay. Whether any such information is actually disclosed depends on many factors such as current market conditions, prevailing practice in the real estate community, the listing agent's marketing strategy, and the instructions of the seller. So our listing agreement, our RLA form, does give permission by default, gives permission to the agent the seller gives permission to the agent based on that form to disclose the content in terms of competing offers. Okay, everybody good? All right, let's take a look at the final part here. We're going to talk about confirmation. Did I just mess up my thing? I think you can still see this, right? Yeah, there we go. Okay, let's talk about confirmation. So remember what I said before, I must disclose the concept of agency, okay? And then I must also confirm it when it happens. So confirming would happen at the time that the buyer was going to actually write an offer on a property. So confirmation, unless the property is, again, 5 or more residential dwelling units, remember 1 to 4 civil code, okay? Broker shall confirm the agency relationship described above or as modified in writing. It must be in writing. And Veronica says you have to be able to defend the fact that you did it. Okay. So, listen, you've all memorized the agency disclosure form, I'm sure, but I need to be able to prove that the buyer has seen it by having them sign the form. Okay. Prior to or concurrent with the buyer's execution of a property contract. So what I have been telling you, it has to happen before the offer is written. And in this case, it has to happen before you do this form, okay, before you have the buyer sign this agreement. Is everybody good with that? It's a very powerful thing. And guess what? Use it to your advantage. Use it to explain to the buyer, this is really important, the things that we're talking about. I need you to understand, I want to be your agent. And as such, you're going to need to sign this agreement. Okay. All right. Everybody good? Let's I'm going to pull up the confirmation really quick. Confirmation form. Whoops. Questions? Okay. No questions there. All right. Please feel free. All right. I'm here for this. Okay. Let's take a look at my form again. So now I've shown you the RA form. Now let's take a look at our confirmation of real estate agency relationships form. And again, this is the confirming form. So I at the time that I get my buyer representation agreement or at the time that I get my listing agreement, I don't know if we're going to be single agency or dual. I know for sure we're single at that point. I just don't know if I'm going to be dual later. Okay, and so the confirmation occurs in the contract on paragraph number 2. So why do we have this form? This is another one. We just updated this form in December of 18, okay? And part of it is because of the law that we had changed. So we actually had the law changed. We now call it the seller's agent and the buyer's agent. Some of you would remember we used to call them the listing agent and the selling agent, and it just created a lot of confusion. So this went on for decades. And so finally we said, why don't we just change the law? It was easier to change the law than to change people's thinking about what it was. Great exam questions, by the way, on the DRE exam. So what did we do? We would change the legislative language, and then therefore went in and changed all of our forms. Now the purpose behind this form is if you didn't confirm agency in the purchase agreement, and I get it a lot where they didn't fill out the name right, they didn't put the right DRE number. Remember, you have to have the DRE number of the brokerage and the DRE number of the agent. And so if that paragraph number 2 of my RPA is not done properly, and in our offices, people that write offers on our listings, it's done wrong all the time because they click on the MLS Connect, and the MLS has collapsed our name, Burke Real Estate Consultants Inc., because it's so many letters. They took all the spaces out, and so now it's just like one great big letter. And so we usually confirm agency because we don't like the fact that it might be confusing as to who we are, okay? So that's just me being a little OCD. Some people like that, other people don't. I'm sorry, but I'm going to provide this additional form, okay? But notice it says right here, as required by the Civil Code. Okay, the law requires it. I don't have to use this form if I've properly filled out and checked the appropriate boxes. So DRE numbers and who represents who in the purchase agreement. Okay, because by the time you've written the offer, now you know whether it's going to continue to be single agency or if it's now going to be dual agency, and you have to tell everybody that. Okay, so this form, this is or this is not an amendment to and supersedes the agency confirmation of purchase agreement. So when we use this form, it is intended to supersede the agency confirmation of purchase agreement because it was done incorrectly, and it's not no dispersion on the agent that wrote the offer. It's just our name sometimes can be a little confusing. Okay, all right. Following agency relationships is or hereby confirmed. Operative word, confirmed for this transaction. Okay, so here's the seller's brokerage firm's information. There's their DRE number. Okay, is the broker of seller landlord. If you check this box, this one will also automatically be checked. Who is, so the brokerage firm, who is the seller's agent? The seller's agent technically is the broker, but now it would have your name in there and your DRE number in here, okay? They made some other changes in here which are kind of interesting, which I was very confused by. So buyer's brokerage firm, again, the brokerage firm's name, the broker's DRE number is the broker of whom? So the buyer tenant, then that would automatically check that box. Your name would go in here if you were the buyer's agent. Now remember, you could also check both the buyer and the seller, okay? And if I do that, now it's dual agent, right? I can do the same thing down here, okay? And the confusing part of all this was where we had language in the old form that said represents the seller only, but it was down here and it made no sense. It was like, well, how could you put it down there? So bottom line is that's how that form gets filled out. It's really easy to do, but it does become required when agency confirmation is not done properly on page 1 of the RPA paragraph number 2. It looks really similar to all of that. This is just the listing agent is going to use this form when in fact the contract is ambiguous or it wasn't filled out properly. And again, not necessarily something that the buyer's agent did. It just may very well be when they clicked MLS Connect, it just came at, it didn't come in right. Okay, so you need to make sure you clarify that because agency is the DRE has a ball with agency, I'm telling you. And like I said, up there with that buyer representation agreement, it's one of those things where they just look at you and go like this. It's like, listen, that's a hint. And again, I don't know, maybe they give me hints, but I've told you before, it's like, Veronica was saying, we're looking at teams now. That was October 2 years ago. And she made a comment in our risk management committee. SDR, of course, has, the imminent risk management department in the country. But she's in our meeting and she says, we're looking at teams now. I'm looking at her and you know what? It's a question on your license renewal. So now on your license renewal, all of a sudden there's a question that says, did you work on a team during your last licensing period? Because you know what? They're looking at the numbers and they're looking to see how many people working on teams. Are they doing it right? Who signed the avid? Did the agent that did the avid sign the avid, or did the team leader sign it even though the other agent actually did it? Those are really serious questions, folks, okay? And they are looking at that. They think that's fraud. When you're not the person that did the visual inspection of the property, don't be signing it, okay? Questions about any of that? I'm going to take you back to me because it's all about me. Every Saturday evening, I do send out an email. That email is an update with clickable links. Like I said, I blew it this week. I'm sorry. I did not know that bit link is case sensitive. So I only send it out once a week. This time I had to do it twice because I messed them all up. I tried to make them look pretty and I blew it. So bottom line is, if you want to get an email from me, please send me this. If you want, in fact, to get access to today's materials, send an email to education@sdar.com and they will just give you access to the folder. Okay, but I want you to be good. I want you to be happy with what you're doing. I want you to make money. Okay, everybody good? I see people signing off, so I'm going to go ahead and assume that you're done for the day. Serena, Linda, Renee, all of you, thank you so much. James, I'm not seeing Mike. Are you on there today? Oh, I hope I didn't. Galena, hi. Art, always good to see you, buddy. Okay, so anyway, thank you all for being here, and I look forward to seeing you tomorrow. We're doing zip forms. I'm going to show you how to create a template. I'm going to make your life so easy. Oh, God, listen, once you do this, you'll do it like this all the time, okay? And I'll be updating my templates for our brokerage on the weekend, and then I'll make those available to you if you want them. So thank you all for being here. James, thank you always. And I wish you the very best. I look forward to seeing you at 10 o'clock in the morning. Again, at 1 o'clock, I'm doing the RPA. We're going to kill it. Okay? All of you, thank you very, very much. I appreciate you, and thanks for being here. And I look forward to hearing from you. Take care for now.